Good afternoon. I'm Louise George Clubb, welcoming you to the second of our 3 lectures on the Supreme Court, and I congratulate you for coming despite the heat and the perennial threat of protests on the Berkeley campus, because it would be pity to lose this lecture, which is going to be special, I think. Amanda Tyler is professor of law. She joined the Berkeley faculty in 2012. Her research and teaching focus on the Supreme Court, federal courts, constitutional law, civil procedure, and statutory interpretation. She holds degrees from Stanford and Harvard and has served as law clerk for Guido Calabrese at the U.S. Court of Appeals and for Ruth Bader Ginsburg at the Supreme Court. She has taught at George Washington University and is visiting professor at Harvard, NYU, and the University of Virginia, and she was visiting senior fellow at the London School of Economics, receiving the Order of the Coif Distinguished Visitor for 2017. Her publications include articles and a co-edited volume on habeas corpus, and this year Oxford University Press is publishing what will be an authoritative work on this subject, entitled Habeas Corpus in Wartime, From the Tower of London to Guantanamo Bay. P.S. In addition to all of this, she was a soccer player in college, and she is a soccer coach right now. So, Amanda.
Thank you, Louise, for that wonderful introduction, and thank you, all of you, for braving the heat to join me here today. It's a real privilege to get to speak to all of you about my work. The talk is entitled Habeas Corpus in the Supreme Court. I am going to be drawing heavily and giving the talk on my book, which is Habeas Corpus in Wartime. I'm loath to touch this computer, lest I screw up the slides further. I'm just going to leave that on there. So a lot of my talk is going to derive from my book, but I promise you I'm going to get to the U.S. Supreme Court in short order to talk about how the Supreme Court has engaged with important questions around habeas corpus during wartime. But in order to do that, I need to give you some background. So let me tell you a little bit about what my book is about and how it will connect the dots to get us to the Supreme Court on American shores, as it were. So I have been working for many years on the manuscript that has become this book. And the idea behind the book was to tell the story, to explore the English legal origins of the writ of habeas corpus, along with the concept of suspension, which we know well from the Civil War, and trace the influence of the English legal backdrop and English political backdrop as well. Trace the influence of all of that on the development of early American law, and particularly early American habeas corpus jurisprudence. Then the book takes the story forward to trace how things have unfolded over the course of American history, always giving special attention to the wartime periods where the writ of habeas corpus has come under threat, and we've seen in some instances, but as I will discuss, problematically not in others, suspension of habeas corpus. So in particular, the book talks extensively about the Civil War, and before that the American Revolution, as well as the periods of Reconstruction, World War II, and of course, the War on Terror. Now, where does all of this begin? For American purposes, we start with Article 1, Section 9, Clause 2 of our Constitution. This is called the Suspension Clause, and it says, "The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it." Now, how on earth are we supposed to make heads or tails of these words? I submit that John Marshall, the great Chief Justice, was right when he said we have to look to English legal tradition to do so. In particular, John Marshall said the words were used in the Constitution in this particular clause as ones that were well understood. Well, they may not be well understood to us today. Indeed, the whole point of my book is to try and make that so. But they were at the founding. They were at the founding. In other words, as John Marshall instructed us, we need to look to English legal tradition to understand what we mean by the constitutional privilege of the writ of habeas corpus, as well as the related concept of suspension. Now, if one instead approaches these questions and tries to decipher this clause in the Constitution solely by looking at modern examples, and particularly the 20th and 21st century examples that come to mind, one might come away with a very interesting take on what this clause is doing in the Constitution. In particular, in the 20th and 21st centuries, we see many examples suggesting that there is a modern legal and political acceptance of the idea that wartime conditions alone suffice to justify detaining citizens in a preventive posture, that is, as something akin to a prisoner of war, without a suspension of habeas corpus. Take, for example, the single largest example demonstrating this point, about which I'll say quite a lot toward the end of the talk, the World War II incarceration of over 120,000 Japanese Americans. And out of that group, over 70,000 were Japanese American citizens. They were natural-born citizens of this country. They were all detained, evacuated, and then detained ultimately for average stays of 3 years in camps based solely on the suspicion that their Japanese ancestry might lead them to spy on behalf of the enemy Japanese Empire during World War II. There was no criminal charges ever brought, and there was no suspension in place on the mainland, although, as I'll discuss, there was one in place in the Hawaiian Territory during the war. Additional modern examples abound, and here we can start with the Supreme Court and talk about a very important war on terror decision called Hamdi versus Rumsfeld from 2004. In Hamdi, the court did not produce a majority opinion. Justice O'Connor wrote for the plurality. But ultimately, cobbling together the votes, she did get enough votes to support the proposition that there is no bar, that is to say there's no constitutional bar, to the United States holding one of its own citizens as an enemy combatant, to wit, in the posture of military detention, held for many years, as Hamdi was, outside the criminal process, never being tried for any crime, and there was no suspension in place. In this case, in Hamdi, we see the birth of the idea of a citizen enemy combatant, but as I'll suggest, the seeds of Hamdi, the foundation of Hamdi, can be found in the World War II episode of the Japanese American internment. Now, Hamdi itself is already bearing fruit. So more recently, in the wake of the bombing of the Boston Marathon, an issue that is near and dear to my heart because I've run it 8 times, several prominent members of Congress suggested that the surviving then suspect, now convicted person who carried out these attacks, should be treated as an enemy combatant. Specifically, various senators, including John McCain, said that those who carried out the Boston Marathon bombings were attempting to kill American citizens and terrorize a major American city. The accused, they suggested, were not common criminals attempting to profit from a criminal enterprise, but instead they were terrorists who were trying to injure, maim, and kill innocent Americans. On this basis, the suggestion was made that the surviving suspect should be treated as an enemy combatant, like Hamdi had been treated, which is to say he could potentially simply be held indefinitely in military detention and never charged and tried with a crime. Now, in this particular case, that's not what happened. Tsarnaev was ultimately prosecuted and convicted, and indeed sentenced to death by a jury in Boston, in federal court. But this issue is right now playing out in the Department of Defense. Less than 2 weeks ago, the Department of Defense disclosed that it had taken into custody an American citizen who was captured in Syria, allegedly fighting with ISIS. And they have labeled that person an enemy combatant. And as of right now, all that we know, because very little has come out since the initial statement, is that this person is being held in military detention, and they are figuring out, that is to say the government is figuring out, what they're going to do with him. Now, what my book aims to do is, starting with these modern examples, go back and look at the history and try to figure out how we got here and ask whether we took a wrong turn somewhere as a legal proposition. And as my book details, there is a wealth of evidence, a wealth of historical evidence, preceding, during, and following the ratification period when we adopted the Constitution, that suggests, indeed overwhelmingly, that this proposition, that a citizen can be held outside the criminal process in the absence of a suspension during wartime, is at odds with everything the founding generation thought they were doing in ratifying the suspension clause. Specifically, the evidence strongly suggests that the entire point of the suspension clause, the animating purpose as it was for the clause to operate as a constraint on the government, precluding it from holding outside the criminal process, detaining outside the criminal process, a person who could claim the protection of the Constitution, a person who could claim allegiance and the protection of domestic law. Indeed, the only way to legalize detaining someone in such a posture is through suspension. Now, because the founding generation, and I'll discuss this, knew the dramatic nature of suspension, they very carefully constricted in the terms of the Constitution when a suspension could be declared. Specifically, as we saw in the suspension clause, it is only in cases of rebellion or invasion when the public safety may require it. In all other cases, the great privilege of the writ of habeas corpus was supposed to be inviolate. Now, how, again, do we make heads or tails of these words, and how do I draw the disconnect that I highlight? To do that, we have to go back and look at the English legal backdrop. So I want to talk about that backdrop before coming back to talk about how all of this law has played out on American shores, and particularly in front of the Supreme Court. Now, the story of habeas corpus begins centuries ago, and it begins with the common law writ of habeas corpus, which was a judicial creation, the very idea of which, at its core, is that a court would inquire of a jailer an explanation as to why he or she is holding a prisoner, and then decide whether that explanation held up. Now, as English history shows, the common law writ was not a powerful enough check on executive excess, as it were. Indeed, the king's authority to detain on his word alone often survived challenges brought under the common law writ. And one case in particular highlights that. In law, we talk about, in my field, that is to say in habeas corpus, we talk about a very famous case called the case of the 5 Knights, otherwise known as Darnell's case. It arose out of the 30 Years' War, when Parliament had cut off Charles I and no longer wished to fund the war. So Charles I turned to English nobility and demanded that various knights loan him, and air quotes are appropriate, because it wasn't voluntary in any sense, money so that he could continue to carry out the war. 5 knights notably refused, and the king responded by throwing them in Fleet prison, at which point they enlisted the help of the great celebrated parliamentarian and legal scholar John Selden to represent them. In habeas proceedings, John Selden argued that this provision in Magna Carta, going back all the way to 1215, it just had its 800th anniversary, chapter 39 in the original Magna Carta, this provision, which says that no free man shall be taken or imprisoned or dispossessed or outlawed or banished or in any way destroyed, nor will we go upon him, nor send upon him, except by the legal judgment of his peers or by the law of the land. John Selden said the law of the land means due process, the concept that we now have enshrined in 2 places in the U.S. Constitution. And due process, John Selden said, means by presentment or indictment. In other words, what Selden argued in the case of the 5 Knights was that the king couldn't throw these knights in Fleet prison without charging them and trying them for a crime in due course. And according to Selden, that's what this passage in Magna Carta meant. Now, Selden's argument was countered forcefully by the Attorney General Heath, who argued that all justice is derived from the king, and he is the font of law and justice. In other words, if the king says they're bad guys and they should be in Fleet prison, that suffices. Ultimately, the knights lost. Heath's arguments prevailed, and indeed the knights were told that they should ask the king for mercy. Specifically, King's Bench said, "We make no doubt but that the king, if you seek to him, he knowing the cause why you are imprisoned, he will have mercy. Now, you can guess how likely that was, given that the king, of course, had thrown them in jail in the first place. But this lit a fire under John Selden. And so he joined camp with Sir Edward Coke, another great celebrated parliamentarian, later Chief Justice of King's Bench and great English legal scholar. And together they promoted, in the year following the case of the Five Knights, the Petition of Right. And in the Petition of Right, essentially, among many things, they sought to rebuke the decision in the case of the Five Knights and embrace Selden's arguments. They did not, however, succeed in the short term. And indeed, a simple fact drives home that point. Within a year of passage of the Petition of Right, the king threw John Selden and several others in the Tower of London. And he did so because they had opposed his efforts to end the parliamentary session. When they sought habeas relief, when Selden in particular sought habeas relief, and you can bet he was helping his lawyer make the arguments, Heath argued in opposition successfully that a petition in Parliament is not law. And once again, they were left to ask the king for mercy and for their escape. Famously, one of those thrown in the Tower of London, Sir John Eliot, never did escape and suffered several hard years there and died. And he is one of many who are buried somewhere underneath the chapel with his name on the wall. These efforts nonetheless set in motion decades of important efforts on the part of others to carry forth Selden and Coke's vision of habeas corpus. And they culminated in a very important event in English legal history that had profound influence on the early development of American law, specifically the adoption in 1679 of the English Habeas Corpus Act. At long last, Parliament passed real binding legislation on the subject and indeed embraced the arguments that Selden and Coke had been advancing so many decades earlier. The Act is crucially important to understanding all that followed in English legal tradition as well as American legal tradition in the context of habeas corpus. Among other things, the Act dramatically changed the law on the ground in England. Parliament, as part of the rise of parliamentary supremacy, took control of the law of detention and took control from the king. Parliament also put in place very strict constraints on when the king could arrest and detain persons, and included penalties for courts if they did not enforce those constraints. In addition, as I've said, the Act proved enormously influential on American law, and I'll speak to that in a moment. The statute was intended to complement the common law writ, and it used the common law writ as a vehicle for enforcing its terms. But among many important provisions, in the original version, Section 7, the Act required that one suspected of treason or suspected of criminal activity or posing a threat to national security, such a person had to be tried within 2 terms, that's 3 to 6 months during this period in English legal history, or else they were entitled to their discharge. In other words, the king could no longer hold people in custody in the Tower of London or elsewhere without charging and proceeding against them in due course in a criminal prosecution. Otherwise, the courts were duty-bound to release such prisoners. And as things unfolded, this came to be understood to apply even in wartime and even to cases of suspected treason. This, of course, is why Parliament invented, just 10 years later, the concept of suspension. So in 1689, we see the first episode of suspension of habeas corpus in English legal history. And it came immediately upon, in the wake of the Glorious Revolution, when William and Mary had taken the throne and James had been spurred to flight. Now, James's supporters were rallying to return him and his line to the throne. William, knowing that there was quite a movement in place, went to Parliament through an emissary and said, I want to behave lawfully. I want to act within the law. I don't want to do anything illegal. And I know that if I arrest people and put them in the Tower of London, who I suspect are plotting against me, They will be released by habeas corpus under the Act. Give me a tool so that I can arrest such persons and hold them until order is restored. Parliament responded by inventing suspension and passing an act of suspension that lasted for but a month in its original form. It was extended, and subsequent acts of suspension were enacted throughout the decades that followed to combat the Jacobites, as they were known, who were trying to engineer the return of the Stuart line. Indeed, there was a suspension in place during the Battle of Culloden, and there were many suspensions over the course of these decades to deal not only with the Jacobites, but also with the threat posed by the French. In every one of these instances, the suspension legislation set aside by its specific terms the English Habeas Corpus Act or its follow-on Scottish equivalent. This is important because it shows the tight link between the concept of suspension and the English Habeas Corpus Act, and it also highlights that suspension was the vehicle Parliament adopted to continue its control over the law of detention, but also to make legal the extraordinary detention of prisoners during wartime where they were suspected of treason. The effect, however, of suspension was dramatic. As this quote from Sir William Whitlock to the House of Commons in 1690 highlights. Now, suspensions empowered both the king and his privy council to arrest. So Whitlock said, if an angel came from heaven that was a privy councillor, I would not trust my liberty with him for 1 minute. Indeed, it was only by setting aside the Act's protections, a thing so sacred as Sir Thomas Clarges complained when they were debating the first suspension, that such arrests could be made legal. This is the backdrop to the United States. This is the backdrop to the development of American law. And as you cross over to American shores, we see numerous pieces of evidence to show that the Americans knew well this legal framework. Indeed, the Americans read William Blackstone and Sir Henry Kerr to glorify the Habeas Corpus Act. Blackstone called it nothing less than a second Magna Carta. And Henry Kerr, in his popular treatise that all Americans studying law read alongside Blackstone, listed the Habeas Corpus Act with Magna Carta and the English Bill of Rights as the most important guardians of English liberties. The Americans, unsurprisingly, wanted this second Magna Carta too. But as things played out on the ground, they didn't get it. Efforts by many colonies to adopt the English Habeas Corpus Act were vetoed by the Crown. And indeed, the Crown repeatedly subscribed to the position as a formal proposition that the English Habeas Corpus Act did not apply in the American colonies. As the colonists marched toward war, they complained about this. Indeed, repeatedly, they complained that they were subjects of an arbitrary government who could not enjoy the trial by jury and the benefit of the English Habeas Corpus Act, as they called it, quoting Blackstone, that great bulwark and palladium of English liberties. In other words, the Americans really knew their Blackstone. But the act remained very much in effect on English soil, and this in time proved a serious problem for the North administration during the American Revolutionary War. A story about one of my favorite figures during this period highlights that. So Ethan Allen, this is a book that my 10-year-old son would read. This is the best picture I could find of Ethan Allen. Ethan Allen and his Green Mountain Boys. We know a little bit about them insofar as we know that they raided Montreal and tried to take the city, but it was fairly poorly planned and they were captured almost immediately. So Ethan Allen and his Green Mountain Boys were put on a ship, and this is in 1775, and sent to England, where they stayed in what looks nicer than it clearly was, Pendennis Castle. In his narrative, which you have to read with a little bit of taking a grain of salt with it, Allen writes about his time at Pendennis Castle, and he says that he has become something of a folk hero by that time. People, he claims, came from all around to see him. And among other things, he says the English people who came to see him were surprised that he and his compatriots, his fellow rebels as they were called, looked fairly similar to them. In any event, what is interesting for my purposes about Ethan Allen's stay in England is that it lasted less than 2 weeks. After going to all the trouble to put him on a boat and send him from Canada to England, he was very quickly put back on a boat and sent back to the United States. Why? This is an important question to ask. Why? Well, all the evidence suggests, all the evidence that I've found on the newspapers and in the archives suggests that he was put back on a boat because very prominent lawyers who were experts in habeas corpus proceedings and who were tied to the American cause, and in one case had actually successfully represented an American who'd been put in the Tower of London and gotten him out just months earlier, had taken up Ethan Allen's case. And they were going to petition for writ of habeas corpus, demanding that he be either tried in due course or released. And the administration advised the Lords of the Admiralty that the principal object is to get the prisoners out of reach as soon as possible. Out of reach of what? The only answer, I think, that we can say is the English courts, who were poised to give a remedy of discharge if they were not charged and tried in due course. So the answer, send him back to the United States, or the American colonies as they thought of this place, where the act was not in place, and the prisoners could be held as military prisoners for as long as possible. Now, as the war waged on, the North administration couldn't keep doing this. And indeed, more and more prisoners came to English shores, and my search of the archives found a series of absolutely desperate memos from the Lords of the Admiralty demanding guidance as to what to do with these prisoners. To answer that, the North administration turned to a favorite advisor, the great English jurist and Chief Justice of King's Bench, Lord Mansfield. Lord Mansfield looked at another case involving an American ship called the Yankee that had been captured by British prisoners and sailed up the Thames River, where the Americans, like Allen, were put on display for all to see. The question the North administration posed to Lord Mansfield is, what can we do with these officers of the ship? We don't want to try them for various reasons, and we don't want to set them free. Mansfield advised that insofar as those officers, those American officers, those rebels as they were known, claimed to be subjects of the Crown, they enjoyed the full panoply of protections of the English Habeas Corpus Act. And that meant, Mansfield advised, that they had to be charged with a crime and prosecuted in short order, or else they would be able to win their discharge in an English court. So the North administration responded as history had taught it. Lord North went to Parliament and asked for a suspension, and Parliament obliged, enacting a suspension applicable to persons suspected of the crime of high treason or piracy committed in America or on the high seas. In other words, the suspension was uniquely targeted at American rebels for activities on the seas or in the American colonies. Where those persons were brought to England for detention, the Act said they could be held outside the framework of the English Habeas Corpus Act. They could be held as military prisoners for as long as the suspension lasted. Lord North, in introducing the bill, said that we need a bill like this so that we can hold the American rebels like other prisoners of war. In particular, for example, like the French, who we've been capturing. The book details the plight of many Americans that were held during this period under the auspices of the suspension, which was extended throughout the war. The suspension only lapsed, that is to say, Parliament only allowed the suspension to lapse once independence became a foregone conclusion, at which point Parliament enacted a statute that recognized that the American prisoners still in custody could be held legally as prisoners of war under the law of nations, and declared that their protections and their rights would be governed by the international law of nations as opposed to domestic English law. But during this period, one of the many people held, prominent Americans held under the auspices of the suspension, was Henry Lawrence, who had been president of the Continental Congress. This is a famous painting of him. You can see the Tower of London over his shoulder. This painting was was made of him while he was a prisoner in the Tower, where he spent some 15 months, all at his own expense, no less. Now, Lawrence had been captured on the high seas on his way to the Netherlands to negotiate their support for the American effort. When they saw the British ship approaching, he threw all the papers overboard, but as he learned, paper floats, so the British were able to figure out what he was up to. And they brought him to England and labeled him a traitor. Now, to show how this legal framework worked, because the British viewed the Americans as traitors and rebels, when Lawrence argued that he was a foreign ambassador with various rights under international law, under the law of nations, the British merely laughed at him and said, "No, you're a traitor, and you're going to the Tower of London under the auspices of the suspension." And they also charged him with a crime, the crime of high treason, and he was only allowed ever his release from the Tower after he posted bond and promised to return and stand trial for treason. Interestingly enough, he later was one of the principals who negotiated the terms of peace and American independence, at which point, this is where he stayed at the Tower of London. I'll come back to that slide, at which point Lord Shelburne said to him in the peace negotiations, "Well, Mr. Lawrence, if we must acknowledge your independence, I shall be grieved. As I have already said, for your own sakes, you will lose the benefit of the Habeas Corpus Act." Now, this should make you chuckle because Lawrence had lived in South Carolina, where its efforts to adopt the Habeas Corpus Act had been vetoed by the Crown, and then he'd been held in England during its suspension. So he'd never really known the benefits of the English Habeas Corpus Act. Now, this is a picture I took doing field research at the Tower of London. I don't know if you can see it, but it says, "Would you put dangerous people in prison?" It's a survey they have, even if there was no solid evidence against them. And you can see that the yeses outvote the noes by quite a huge margin. So it seems that I have my work cut out for me. All right. Now, crossing the Atlantic, we want to take this story forward to the American shores. Unsurprisingly, there is a ton of evidence to suggest that the English Habeas Corpus Act and the suspension framework I have described influenced American law. So, for example, in South Carolina, Henry Lawrence's home state, the very first order of business for its newly declared independent assembly was to confirm operation of the English Habeas Corpus Act in that state. And in 1777, to take another example, Georgia adopted its constitution, and in its constitution it provided that the principles of the Habeas Corpus Act shall be part of this constitution. Lest there was any doubt what they were referring to in terms of the Habeas Corpus Act, the original distribution of the Georgia Constitution appended copies of the English Habeas Corpus Act. Now, during the Revolutionary War, moreover, at least 6 states enacted suspensions of their own, in many cases expressly setting aside the Habeas Corpus Act. 2 of these, one of the suspensions was in Massachusetts, and Massachusetts then later had a suspension to deal with Shays' Rebellion, which of course weighed very heavily on the founders who went to the Constitutional Convention to write the Constitution. It is also the case that in the years following independence, the states, in a wave of adoptions, adopted statutes that were built and predicated upon the English Habeas Corpus Act. And this list includes most prominently New York, which adopted just such a statute, which tracked the English Act almost verbatim, only 3 months before the Constitutional Convention. So this is the backdrop to the Constitutional Convention, which occurred in Philadelphia in 1787. And as you could guess, all of this backdrop and this English legal framework dramatically influenced the adoption of the suspension clause. Indeed, among many other details that I uncovered in going through the English archives, the author of the suspension clause, Gouverneur Morris, had a cousin, Isaac Gouverneur, who had been detained in England under the auspices of the Revolutionary War suspension. So it suggests that he was very familiar with these concepts. And indeed, there is a lot of evidence to be found during the convention and ratification debates to suggest that this English backdrop heavily influenced the writing of the Constitution and the suspension clause. In particular, to take one example, Alexander Hamilton, who is famous in my world not just for the musical, I'm making sure you're awake because it's very warm in here. He wrote in the Federalist Papers that the Constitution should be celebrated because for many other reasons, it provides for trial by jury protected by the Habeas Corpus Act. So there is a lot of evidence during the founding period that this backdrop influenced the adoption of American law. And indeed, this influence was confirmed later by Chief Justice John Marshall, who said in an important habeas decision, Ex parte Watkins, that the Constitution's habeas provision is founded on the English Act. Indeed, he said, to interpret the suspension clause, we must look to the law which is in a considerable degree incorporated into our own. And then he specifically cited the celebrated English Habeas Corpus Act. All of this sets the backdrop for American history as it unfolded. And what we see is that George Washington and James Madison and John Adams in the early years in dealing with various insurrections did not embrace the suspension authority and in addressing the War of 1812. Thomas Jefferson did request a suspension to deal with the Burr conspiracy. It failed in the House after passing the Senate in a secret session. And as a result, litigation that was going on with respect to prisoners who were being held in military custody, which would have resulted in their release, wound up driving the Jefferson administration to charge those individuals with crimes, whereas other military prisoners had already been released. And all of this sets the backdrop to the Civil War. And here, finally, our Supreme Court is going to come in more prominently to my discussion. Now, I want to talk about the Civil War and World War II, mainly with my remaining time. Now, the Civil War, we all know about the so-called Great Suspender, Abraham Lincoln. Now, I didn't coin that phrase. My friend Cy Prakash did. But Abraham Lincoln suspended almost right out of the bat. And he did so to protect the rail lines and to protect the Capitol. Congress was slow to the table. It took Congress 2 years of actively debating legislation before it finally passed a suspension. Lincoln subscribed to the position famously that he had the authority to do this ahead of Congress, and I'll speak to that in a moment. But importantly, he also subscribed to the position that without a suspension, he could not hold those who were fighting for or in any way aiding or sympathetic to the Confederacy outside the criminal process. And he pointed to the suspension clause as itself making the distinction between arrests by process of courts and arrests in cases of rebellion. And he said the very purpose of suspension was so that men may be held in custody whom the courts acting on ordinary rules would discharge. In other words, he said, I have to suspend, otherwise I can't hold the bad guys, as it were, without charging them with a crime and trying them in due course. As Lincoln understood suspension, that meant he needed it even to hold captured Confederate soldiers in something akin to a posture of a prisoner of war. And indeed, his suspensions, at their broadest, embraced, by their terms, Confederate soldiers who had been captured. This is important, and this follows from Lincoln's view, shared by the Union more generally, that those fighting for and living in the Confederacy and supporting the Confederacy all still owed allegiance to the Union. They could not legally secede. And so, because they owed allegiance, it followed that they enjoyed the protection of domestic law. Now, those of you who know about this period, and particularly the political and legal aspects of this period, surely know that Lincoln and Congress were not consistent on this point. But they were consistent on this point as it applied to the concepts of habeas corpus and suspension. Where the model broke down, however, was when Lincoln claimed the mantle of suspension for himself. So Lincoln was quick to the gate in suspending, and this was enormously controversial. This is one of my favorite cartoons of Lincoln from the period. He's stomping, I don't know if you can see it, on the Constitution, law, as a general proposition, as though it could be in one book, and habeas corpus. And it was very controversial what he did, both in the North and in the South. Indeed, in the South, Jefferson Davis made it a rallying cry. In his second inaugural, in February of 1862, Jefferson Davis complained, if you go down to the bottom, that there were bastilles in the North filled with prisoners arrested without civil process or indictment. And he complained about the fact that the writ of habeas corpus had been suspended by executive mandate. He was using the complaints about trampling on civil liberties by Lincoln to rally his base, as it were. Of course, the Confederacy suspended habeas corpus 5 days later, after he gave the speech. But importantly, the Confederate Congress enacted the suspension. Jefferson Davis never got out ahead of the Confederate Congress. And indeed, in the third suspension passed in the Confederacy, the Confederate Congress declared that only the legislature could suspend habeas corpus. So as a matter of contemporary evidence, there is a contrary view staked out there. Now, all of this came to a head in the case of a man named John Merryman. In his case, he had been captured under one of the initial suspension proclamations which Lincoln had declared, and that empowered his military leaders to capture people who were trying to disrupt the travel of federal troops from Massachusetts to the capital. John Merryman allegedly had been burning bridges, and so he was captured and held at Fort McHenry. Now, he had a relative who was a lawyer who very quickly, practically immediately, filed for a writ of habeas corpus. And it went before Chief Justice Taney, who was the circuit justice presiding over Baltimore. In a very heavily attended hearing, Chief Justice Taney demanded an explanation as for why Merryman was being held. And when no warrant or indictment was produced, Taney declared that he had to be released. He said, if the President of the United States can suspend the writ, then the Constitution of the United States has conferred upon him more regal and absolute power over the liberty of the citizen than the people of England have thought it safe to entrust to the crown. Now, Taney, one wants to be very careful about relying on Taney. He's a very controversial person, and he wrote some of the worst decisions the Supreme Court has ever issued. But he did know his history. And throughout his opinion in Merryman, he talked about John Selden and John Selden's arguments in the case of the 5 Knights and John Selden's later detention. And he said, in effect, all of John Selden's efforts were for nothing if Lincoln is right. And while I would say one has to be careful about relying on Taney, on this I think Taney was correct. Obviously, we can talk about, notwithstanding the legal framework, whether Lincoln should have still done what he did. But it was extra legal in my view. This is because the entire history of suspension and habeas corpus tells a story of the legislature taking away the control of detention and detention law from the executive. It is a story that is suspicious of the executive, that does not trust the executive to take proper consideration of individual liberty. And indeed, it's a story that's even suspicious of the royal courts. It is also the case that those who wrote our Constitution were deeply suspicious of centralized executive power. Indeed, the Articles of Confederation that had controlled in the interim period between independence and ratification of the U.S. Constitution did not even provide for an executive. It's hard to see how the founding generation could have subscribed to the view that the president could suspend on his own. And indeed, in the convention debates, there was strong opposition to recognizing a suspension power at all. People were deeply suspicious of the abuse of that power. Now, going forward, there were other important Supreme Court cases during the Civil War, many in fact, but one that I want to speak to very briefly, with which you might be familiar, is Ex parte Milligan. Now, Milligan was decided shortly after the war, and that may indeed play a role in the fact that it was decided the way that it was. The Lincoln administration had subscribed to the position that it could try civilians with military tribunals, and indeed the Lincoln assassins had been so tried. Milligan was a case that posed the question to the Supreme Court whether this was constitutional. And the Supreme Court, 1 year after the war, held that it was not. Held that individuals who lived in states where the courts were open and operating were entitled to the full panoply of criminal procedure rights, including trial by jury and all the other Bill of Rights amendments that apply, even in times of war, in the criminal process. In other words, they could not be tried by military tribunals, and Milligan's death sentence was thrown out. Importantly, in Milligan, the Supreme Court also held that it was not the case, and history provided no support for the argument, that the suspension that was put in place for the entire Civil War, first by Lincoln nationwide, ultimately by Congress, and then again by Lincoln, acknowledging that Congress had also conferred on him this power, did not justify, that is to say, suspension did not justify trial by military tribunal. And that's a very important proposition that Milligan established, a proposition that I think is correct. Suspension has always been about temporary detention, not about proceeding toward punishment through streamlined procedures. And that's important because looking backward, it explains why the the Johnson administration was so nervous about how it was handling the Lincoln conspirators, some of whom were put to death, but some of whom were given shorter sentences and were sent on purpose to Fort Jefferson in the Florida Keys so as to get them beyond the reach of a habeas judge. Indeed, internal correspondence within the administration shows that's why they were sent there. Nonetheless, the spouse of Samuel Mudd, the doctor who treated the assassin's broken leg, she did bring a habeas petition on his behalf in Florida, which was quickly dismissed on the merits, the judge saying Milligan didn't apply, which is not entirely right, in my view. Not entirely right. The courts were open and operating in the District of Columbia when there was a streamlined military trial of all of these individuals. Now, all of this poses a question. And this is the question that led me to write my book. How can it be against this backdrop that over 70,000 American citizens, natural-born American citizens, were detained outside the criminal process based on a generalized suspicion of disloyalty during World War II, all in the absence of a suspension? All of this unfolded in the months that followed the Japanese bombing of Pearl Harbor in December of 1941. And there was never a suspension on the mainland. There was in Hawaii, but there never was on the mainland. And indeed, I subscribe to the view that there couldn't have been a suspension, a constitutional or valid suspension on the mainland. The question is much closer, obviously, in Hawaii. At the outset, let me pause and say, over 120,000 Japanese Americans were evacuated from their homes, forced to report to assembly centers, and then sent to so-called relocation centers, that is to say, the camps. 70,000 of whom were citizens. That number would have been higher, and it's important as we look back on this period of history to take that into account, because in the 1940s, the naturalization laws did not allow Japanese American immigrants, because of their ethnicity, to naturalize. Only natural-born citizens, the second generation, as it were able to become citizens, and that's because of the natural-born clause in the Constitution. Now, on the mainland, the policy of forcing Japanese Americans from their homes and eventually into relocation centers followed under military regulations that were issued by General DeWitt here on the West Coast under the auspices of Executive Order 9066, which Roosevelt had issued in February of 1942. And they were given enforcement, or teeth as it were, by a law passed by Congress that didn't directly engage with the issues, but said a violation of military orders issued under 9066 would be treated as criminal activity. Now, subsequent evaluations of this episode have focused on the discriminatory aspect of these policies. They were directed solely by their terms at persons of Japanese ancestry. And it's easy to see why the evaluations have focused on this aspect of what happened. German Americans and Italian Americans were not similarly treated. And one doesn't have to look very hard to find indicia of racial animus directed at these persons. Indeed, the Supreme Court itself fell victim to such practices. In the famous case of Hirabayashi, which was decided during the war, the Supreme Court went so far as to question the ability of all Japanese Americans to assimilate into American society. That case was decided in 1943. But there was, as my work, I hope, highlights, another very serious problem with what happened during this period in American history, and it is this. The mass incarceration of Japanese American citizens was a gross violation of the suspension clause and at odds with the whole history of the suspension framework as it had unfolded over the course of Anglo-American legal history up to that point. Notably, it turns out that a number of prominent members of the Roosevelt administration recognized this very truth at the time, and indeed in the months leading up to issuance of 9066 argued that the policy was unconstitutional if it proceeded toward internment. At the top of this list is Attorney General Francis Biddle, who said in January of 1942 to a member of Congress, "Unless the writ of habeas corpus is suspended, I do not know any way in which Japanese born in this country who are American citizens could be interned." Indeed, this point was made to Congress, it was made repeatedly to FDR, and all to no avail. Instead, those in the War Department who were pushing for aggressive measures, their voices loomed larger, were louder, and were ultimately followed by the President. The statement of one War Department official during this period, I think, highlights the mentality. Assistant Secretary of War John McCloy said, "If it is a question of safety of the country, the Constitution of the United States, why, the Constitution is just a scrap of paper to me." Now, as many have documented, there was also no factual basis for what transpired. Indeed, studies had shown that any persons who were possibly of a concern on the national security front were already in custody or already under the FBI's surveillance. And indeed, during this time, FBI Director J. Edgar Hoover, who, let's be clear, was no stranger to robust surveillance, said that the push for internment was based primarily upon public and political pressure rather than on factual data. And so, notwithstanding these legal and very serious factual concerns, the policies were implemented all the same. And Japanese Americans spent an average of 3 years in the camps. I want to show you a few pictures. This is a picture of a grocer in Oakland who's being forced to evacuate and sell his business. He's a graduate of UC Berkeley. He was a graduate of UC Berkeley. This is the sign he put up. Here's some pictures from some of the camps. This is Manzanar, children in the camps, and this is how the camps were guarded. Now, throughout all this, I'm going to talk for just a few more minutes about Earl Warren and the Supreme Court's treatment of these issues. Earl Warren was Attorney General at the time in California, and he was running for governor. And he was running for governor in part on these policies. So he filed a number of briefs in a number of cases in the courts, and there were a lot of habeas cases that came out of Hawaii and its suspension, in which he argued that preventive martial law, which he said was in effect in California, legalized everything that was going on here. And he also said it gave the military a wide range of discretion to do what it wanted. He further argued in his briefs that the constitutional rights of an accused are not denied where detention by the military authorities of evacuated persons is preventive and precautionary only. Now that's a pretty sweeping assertion, that being forced from your home and into an internment camp doesn't violate any of your rights. It should raise more than a few eyebrows. Now, as things unfolded, 4 cases out of the mainland policies made their way to the Supreme Court, some of which are famous, particularly Korematsu. At the law school, we teach Korematsu as what we call an anti-canon, which is to say it's wrong. A companion case to Korematsu was Ex parte Endo, and I want to tell you about Endo because it is the most important case on this particular issue, which is to say Endo is the only case that directly challenged the internment policy. Mitsui Endo had been born here in California. She was a natural-born citizen, and she was an employee of the state of California. Now, when all of these policies began to be implemented, the state of California fired every employee who had Japanese ancestry, including Endo. Meanwhile, I should note, her brother was fighting in the Pacific for the United States Army. She had a lawyer named Jim Purcell, who was from San Francisco, and he originally came in as a friend of the Japanese American Citizens League. He had done a bunch of work for the Japanese American Citizens League, and they asked him to come in and represent the fired employees. Now, he had a client who had been forced from his home to one of the so-called assembly centers. And as he was deciding about how to pursue the employee's case, he went to meet his client at the assembly center to sign some papers. This was at Tanforum, the racetrack. The military had taken the horse stalls and had used white spray paint to spray paint over the uncleaned horse stalls, which is to say they just spray painted over horse manure and hay and everything else. And families were living in these stalls while they were then being sorted and sent to camps. Jim Purcell took one look at this and he said, "This cannot be." He had grown up the son of a prison guard at Folsom Prison. And he said, it's wrong that these people who have not even been charged with a crime are being treated worse than the convicted felons at Folsom Prison. And he decided then and there to challenge the policy wholesale. And he used a survey sent to the California employees to pick out Endo as his best habeas petitioner. And he chose wisely. Well, his reasons for choosing her were that she was a Methodist, she'd been born here, she did not speak Japanese, she did not go to a Japanese school, and she had a brother fighting for the army. But one of the other reasons he chose wisely, I would submit, is because although she was very young, she was in her early 20s, and although the government quickly separated her from her parents, sending her to Topaz, Utah, and leaving them at Tule Lake in Southern California, the government knew that her case was going to pose a very serious threat to the policies. And so it did in her case, or it tried to do in her case, what it had done successfully historically in many habeas cases, and most recently in a number of really important and threatening to the government habeas cases coming out of Hawaii. It offered her release. Habeas corpus means to have and receive the body, which means that for a court to exercise habeas corpus jurisdiction, it has to be able to take jurisdiction over the body of the prisoner. If the prisoner is released, the jurisdiction goes with it. But Endo, knowing this, refused release and spent an extra 2 years in the camps. When she wrote later about why she did that, she said, "I wanted to prove that we of Japanese ancestry were not guilty of any crime and that we were loyal American citizens. That's what kept me from abandoning the suit, at great personal sacrifice." Now, Endo's lawyer, Purcell, who'd been trained at Stanford, he really knew his law, and he knew Milligan, and he knew all of the lofty aspects of Milligan that said ours is a constitution in both times of peace and times of war. And he argued, he took the case all the way to the Supreme Court. It was the only case he ever argued in the Supreme Court. And interestingly enough, he needed a place to prepare for the argument, and Dean Acheson gave him his office to prepare. And in his brief and in his argument, he said that Ex parte Bowman, a habeas case arising out of the Burr conspiracy, and Ex parte Milligan, the post-Civil War case, make it clear that the Japanese-American internment violates the suspension clause. He said, among other things, since the military authorities have no jurisdiction by virtue of a presidential proclamation to try a civilian for an alleged offense in a district where the civil courts are open, how much less right have they to imprison a citizen without any trial at all, when he is neither charged with nor suspected of any crime, and when, as in this case, the loyalty is not called into question. Now, he also argued the existence of a state of war does not suspend constitutional rights, another thing which Milligan had said. In deciding the case, the Supreme Court did not go down this path, although it grabbed onto the last part of the question posed by Purcell. Instead, in an opinion written by Justice Douglas, the court said that the military regulations in place did not permit the continuing detention of anyone who had passed a so-called loyalty test. And because the government had conceded Mitsui Endo's loyalty, it followed that she had to be released. This was not the sweeping victory Purcell had sought, and it was not a decision that wrestled in any way, shape, or form with the very lofty constitutional issues that were in play in the case. Indeed, Justice Douglas said, "We'll mention various constitutional provisions, but we don't want to stir the constitutional pot. We're going to decide this case very narrowly." Interestingly, the court also held up issuing the decision. And when you look at the papers that went back and forth between the justices, one finds a very angry memo written to the Chief Justice by Justice Douglas complaining that the case is being held up. We all agree she should be let out. Why are we not issuing the opinion? And the answer is likely twofold. One, the court waited for the 1944 election to see FDR reelected. And two, the court was going to tip off the White House, which it looks like Felix Frankfurter did, that they were going to get a loss, albeit a narrow loss, but a loss all the same in the Indo case. And indeed, as things unfolded, FDR is reelected. He too had been resisting closing the camps until after the election. After the win, he says, okay, we can close the camps. The government announces that it's going to start closing the camps, and Ex parte Indo is announced the next day by the Supreme Court. Now, in my view, to try to bring all of this full circle, Ex parte Indo, as well as Earl Warren's arguments about these issues when he was Attorney General, really missed the forest for the trees. Throughout history, when one is suspected of disloyalty or even treason, and that person can claim the protections of the habeas privilege, either under the English Habeas Corpus Act or through the suspension clause. The law of Anglo-American habeas jurisprudence has always required that one be tried in due course on criminal charges or released. And the only workaround, and this workaround is constitutionalized in the suspension clause, is a valid suspension, which can only be declared in very limited circumstances under the American Constitution. So contrary to the suggestions of the Indo Court, it does not matter whether a person has passed a so-called loyalty test or not, assuming we could even test that. The key point is that detention outside the criminal process, even in wartime, can only follow through timely criminal proceedings or a valid suspension. That is to say, without a suspension. Let me rephrase. Detention can only follow through the criminal process. And as I argue in my work, we have to remember in all of this that the habeas privilege was born out of originally a judicial writ and a parliamentary exercise to take control of the law of detention, to constrain the executive, and also to constrain the courts from refusing to honor the protections of the Habeas Corpus Act. So there's much to be said about how something like this could have happened in American history, and indeed FDR doesn't come off too well in all of this. Biddle, writing his memoirs through his own lens and gloss, said that FDR wasn't pushing back. In talking about FDR at the bottom of this quote, he says, "I do not think the constitutional difficulty plagued him. The Constitution has never greatly bothered any wartime president." That was a question of law, Biddle wrote, which ultimately the Supreme Court must decide. But it didn't decide it. Endo was a half victory, if that. And indeed, the question I pose in my work is, if the courts will not protect the privilege in times of war, who will? Or as a law professor at Yale wrote shortly after these decisions were handed down, "It is hard to imagine what courts are for if not to protect people from unconstitutional arrest." I think in all of this we need to be mindful of what Justice Tom Clark, who had extensive involvement in the laying out and implementation of the military regulations that led up to the Japanese-American internment, when he wrote about it after the fact, he said, "We need to bear in mind," and here this is a different take on McCloy's statement about the Constitution being just a scrap of paper, that constitutions and laws are not sufficient of themselves, but must be given life through implementation and strict enforcement. So I think about all of this in the context of today. To wrap up so we can take a break and then have Q&A. The administration today is arguing to the Supreme Court in the travel ban cases, which look like they're likely to be declared moot, and had argued throughout the litigation that these are questions of national security. And the courts are bound to defer to the executive branch on questions of safety and national security. That the courts shouldn't question assertions predicated on the needs of national security when they are made by the executive. I think this episode, this World War II episode in particular, suggests that, if anything, courts should be wary of such assertions. And indeed, the executive branch may be poorly situated to check itself internally for compliance with our constitutional values, especially in times of war. And courts defer to executive branch assertions about the needs of national security during such times, arguably at their peril. Further, I would say that I hope this work and this historical work shows, if nothing else, that the court's recognition in Hamdi of the notion of a so-called citizen enemy combatant is at odds with everything the suspension clause was designed to achieve, and at odds with the history and liquidation and understanding of that clause all the way through Reconstruction. Instead, it is a concept that is predicated on a glaring wrong turn that our habeas jurisprudence took during World War II that was not rebuked as it should have been fully in the Endo case. It is my hope that my work will draw attention to this period in history and will lead others to look at it as I do, as a wrong turn, as well as a cautionary tale of the need for courts to be especially vigilant in protecting our constitutional values in times of war. So with that, let's take a break and try to cool off, and then we can have some Q&A. Thank you.
Thank you for a wonderful talk.
Thank you.
I really enjoyed it, and I learned a great deal. There are two things I would like a little clarification on. One of, I can guess because I know a little Latin, but I don't know the origins of the term habeas corpus. which sounds like you have to produce the body or something like that.
Yes.
But I'd like a little clarification on that just for fun. And the other question, I didn't hear a clear verdict on your views on what you thought about Lincoln's argument that he had the right to suspend.
So on the first point, let me say, habeas corpus, as it's been understood, maybe I'll pull this down just a little. Habeas corpus, as it's been understood, now is that not loud enough? There's a happy medium there. Okay, we'll try that. Is to have and receive the body is the idea. And there are a bunch of really fancy Latin phrases, different ones, for different versions of habeas corpus at common law. So habeas corpus at common law, and I don't know all of them by heart because I don't speak Latin, even though I went to a Catholic school where you were supposed to study it. I didn't pay attention. But there are some that are to move prisoners around in civil proceedings. There are versions of habeas corpus traditionally that were used in the family law context that are very outdated. The version with which we are concerned in the full phrase, I would butcher it if I tried to say it out loud, is to have and receive the body. And the idea is that the habeas corpus proceedings proceed against the jailer or the custodian who has the body within his or her control, and that's how the jurisdiction operates. And it follows that if the person is released and there's no one within the custody of the jailer who can be reached by the court's jurisdiction lapses. And so as I mentioned, historically, it has been a popular tool of the government, and this goes all the way back to English legal tradition, to move or release prisoners to get around the exercise of habeas jurisdiction. Now, as to Lincoln, and your question, I'm sorry if I wasn't clear. I think Lincoln was wrong. I think there's great moral force behind what Lincoln did. He was trying to preserve the Union in getting out ahead of Congress to declare a suspension. He did what he thought he had to do, and indeed, historians mostly, I think, agree that he had to do what he had to do to preserve the capital and not let it be cut off. But as a legal proposition, as a constitutional proposition, I think the executive getting out ahead of Congress is impossible to square and reconcile with the English legal tradition that informed the development of this law, which was all about, through the English Habeas Corpus Act and acts of suspension, taking control of these matters away from the executive. This is law that was born out of a suspicion of executive abuse of power at the expense of individual liberties. And so I do think Taney was correct. Now, is the story more complicated in the Civil War? Yes. It's more complicated in a lot of regards. So, for example, Taney refused a request for a continuance. In the Merryman proceedings, there was a request made by the representative of the general who came to the proceedings saying, I don't know anything about anything. Can I talk to the president? Can I stake out and get a better idea of what our position is? And Taney refused that and blazed right ahead to rebuke Lincoln. So there is very much a partisan aspect to this and a rush to judgment. The ultimate conclusion is correct, I think, and Lincoln did present Congress with a defense of the authority to suspend on his own, which I find unconvincing because it really doesn't wrestle with the English legal history, and at root the argument was the English legal history is not important. I find that proposition impossible to accept. Indeed, the English legal history informed everything that followed. But it is also the case that Lincoln might look better if Congress had taken up the matter sooner. And maybe one of the reasons it didn't is because Lincoln got out ahead and indeed declared a nationwide suspension before Congress ever even passed its own legislation. So there was no urgency posed to Congress. So there's a little bit of a chicken and egg problem there as well. And then there's also the added problem that was much more real then than we would see today, arguably, that there are periods where Congress might not be able to meet. And so that's one of the harder questions, is if Congress can't meet and we're in this dire situation, can the executive get out ahead of Congress? What I say about this in my work is that's the only possible argument the only possible sphere where the executive can get out ahead of Congress, because the history and the design of the Constitution really wants this to be a legislative determination. To the extent that the legislature can't meet, then arguably, maybe, it's okay for the executive to get out ahead. But only then, and only until, at most, only until the legislature can convene and take up the matter for itself. Otherwise, all of these principles that are at stake fall by the wayside.
Yes, I'm very interested in what your response to the following argument would be. If you take moral ethical theory, I don't know of any moral theory that gives privilege to existing laws, because if the laws or the Constitution is wrong for one reason or other, perhaps changing historical conditions, I think that they could be changed on the basis of the ethical considerations. So to me, the crucial question, and there's no question that terrible injustice was done to the Japanese, and that habeas corpus, civil liberties are something we should have as much as we can possibly get. But to me, the criteria for changing or suspending habeas corpus would not really involve on the history of legal precedents, but would revolve on the consequences of not suspending habeas corpus. In other words, consider the following thought experiment. Okay. Imagine that terrorist acts greatly increased. People were blowing up bombs in shopping malls. I think there'd obviously be a threshold of tolerance. And I don't think the question of what to change would be to go back and examine legal precedent. But I also see it as a problem of enormous difficulty, because one argument is you just wait until there are enormous numbers of terrorist incidents till you reach that threshold. But a lot of people feel, or are likely to feel, that you have to. I just think it's very, very difficult. And I think fundamentally the clue is, what are the consequences of not suspending habeas corpus?
Yeah, so this is an interesting thought experiment, to use your phrase, about what do we do when the situation gets genuinely dire, and how does this clunky old framework serve us in that context? I have a colleague, a senior colleague, so I have to take his arguments seriously. Dan Farber, he's a renowned, wonderful, brilliant law professor and legal scholar, who wrote a book about Hamdi that was deeply critical of the dissent that I embrace, written jointly by Justices Scalia and Stevens, who are a very odd pairing. They don't always line up in jurisprudence. And I always say, when they do, you better pay attention, because they might be onto something. But Professor Farber argued, along similar lines, that their position, that the only option the government had was to charge Hamdi with a crime. He was a natural-born citizen, captured allegedly fighting with the Taliban, brought to American soil for long-term military detention. They took the position that the options available were charge him with a crime or suspend, declaring 9/11 an invasion. And then you can hold him that way. And that was the choice, as Justice Scalia posed it. And Professor Farber says that's putting the government in a straitjacket. Isn't the Constitution more flexible than that? And indeed, Justice O'Connor's opinion in Hamdi is an opinion that is all about flexibility. She says, when we're facing these kinds of difficult problems, in the war on terrorism, which is a new war of undefined terms, and we don't know how long it's going to last, it doesn't look like traditional wars, it's hard to translate this historic framework into the modern setting. And all of that is true. All of that is true. I don't disagree with any of that. But when we think about constitutional law, I think we have to look at the Constitution as a document that is written at various levels of generality. And there are aspects of the Constitution that are written at a very high level of generality. So, for example, the 14th Amendment talks about equal protection of the laws being enjoyed by all citizens. It doesn't say all citizens of a particular race. It doesn't say all citizens of a particular gender. It says equal protection for everybody. That's written at a pretty high level of generality. That's very different from the clause that says the president has to be 35. That's very specific. That's very specific. So then that begs the question, where does the suspension clause fit in all of this? Because we wouldn't sit around and argue that 34 and a half is okay. It's pretty specific, 35. It's pretty specific. I mean, there are some people, to be sure, who would argue 34 and a half if he or she is especially mature, unlike our current president, then that would be fine. But it says 35, and it's quite specific. When you look at the suspension clause and you look at the connection between suspension and the constitutional habeas privilege, it's a pretty tight connection. It's a connection that goes back centuries. And that developed over time in a very specific way to suggest that there's a very specific lever for adopting and carrying out the extraordinary power of arresting and detaining people outside the criminal process. There's an on-off switch, as it were. And indeed, when we look at the Constitution, Robert Jackson said the suspension clause is the only express emergency provision in the document. So when I look at this history and I look at how it's been understood over time, I think there is a very specific purpose to suspension. It's a very limited emergency power that in a very specific, not necessarily obviously on its face, but by the history that informs it, a very specific provision in the Constitution that says, here is a tool, it's not supposed to be used lightly, it's really only supposed to be used in extreme situations, and to the extent that there's going to be any balancing or any debate about how to apply this to modern considerations, a lot of that needs to be done by Congress in deciding whether to take this dramatic step, whether to go on record in taking this dramatic step. And then I've argued in my work there's a role for the courts to play in supervising that. But to subscribe to the view that because we have changed circumstances, which is really an O'Connor view in Hamdi, we need to balance the government's interests against those of individual liberty. And here she says, as will always be the case in wartime, as will always be the case when we're talking about terrorism, the government's interests are really, really strong. They're always going to outweigh the liberty interests in not being held outside the criminal process. And I don't think the founding generation that wrote the Constitution allows for that balancing to take place in that way. I think it says if we're going to take these things into account, we can only do it where there's a rebellion or invasion, and it's for Congress to debate and take ownership of this decision. And to the extent that they abuse it, then the courts step in, or the president abuses it. In other words, to take your thought experiment, yes, we could have a string of terrorist attacks, and we could all be very unnerved. When I was living in London for 7 months earlier this year, it's very unnerving what's going on there. But traditionally, this body of law has been about working within the law. And this is the framework within which we work. And for better or worse, the founding generation constitutionalized this framework in a document that, as John Marshall says, was designed to be permanent. It does have an amendment procedure, and I suppose if things got bad enough, we could revisit some of these questions. But to walk away from a framework, a very specific framework that was adopted in a binding constitution, it's troubling because it opens up the power, the very extraordinary power of suspension, to significant abuse.
I have two short comments. I always thought habeas corpus meant that if you charged me with murder, you'd have to show me the corpse. I've been wrong for 70 years.
Now you know. Now you know.
And I also have some empathy with people in the 40s who were scared to death. I myself would not bomb Hiroshima. and I wouldn't put people in prisoner of war camps, but I wasn't very aware back then. And I think that fear has to be recognized. I mean, we should give them a little bit of charity.
Fair enough. So we were at war. We were at war. But I think what my work tries to do, I hope, I aspire to do, is to transcend the given circumstances of a particular period, draw the lessons we can from that period, learn. I think the best thing we can do from World War II is learn from what happened so that it doesn't happen again. So that it doesn't happen again. And that's really what I'm trying to do. I'm not trying to necessarily assign blame, but I would like to see the government do better as these issues arise anew. And I think, the two major, among many lessons we can learn, the two major points I tried to make at the end, which I think are very timely today, are that we need to be careful about assuming the executive branch will check itself for compliance with our constitutional values. And I would say that of any executive branch, but I would say it particularly about this one. And that the courts need to recall in all of this, I say more about this in my work, that by design in the Constitution, and this is something Alexander Hamilton said in Federalist 78, one of the best Federalist papers because it's about the courts. He said the courts, by design, are independent. Our federal judges have life tenure so that they will be independent of political winds, and they are supposed to stand between the people and the government. And these aren't his words, but effectively what he's saying is to make sure the government turns square corners and doesn't trample over the constitutional rights of the individual members of our society. And so I think a very important lesson we can learn from looking back and studying these periods are how courts have or have not fulfilled that role, and why it's so important that we honor Hamilton's vision of the role of the courts in our constitutional structure.
My question is about Earl Warren. My teacher, Dr. Hashimoto, was one of the kids that at 10 years old was hauled out of his house and put in a camp. And whenever Earl Warren would come and speak in California, he had a colleague that would hold a sign up and say, "Apologize for the camps." And what Dr. Hashimoto said is he never did.
He never did.
However, in his autobiography, there's a posthumous apology. And I'd be interested to know if you feel like that was actually his words, or maybe his widow put it in. The other thing I'd like you to comment on as an attorney, I said, well, some of the decisions that he pushed through when he was on the Supreme Court, in a way, were an apology. I agree he should have apologized directly, but I'm just curious about your historic view of that.
Yeah, so Earl Warren is a fascinating character in all of this. I mean, I teach at UC Berkeley School of Law, from which he graduated. He is the only Supreme Court justice we can claim. And he was a great Supreme Court justice. But his history is complicated. I confess I was not aware of this posthumous apology. I'm going to have to go and look at this. In his autobiography, thank you. Ted White is a legal historian at Virginia who wrote a biography of Warren, having clerked for him. And he talks a lot about this period in Warren's life as the great stain on his legacy. And he goes into some detail on this question of whether he ever apologized. And on Ted White's account, which I have read, there never was a formal apology. He said things that suggested he recognized the error of his ways. I'll speak to the balance of his life afterward. And there was one interview in which he was asked about the kids who were affected, where he apparently started to cry. But to my knowledge, there had never been an actual formal, public in any way, apology or formal recognition of wrongdoing. That being said, on the Supreme Court, Earl Warren did a lot of great things. There's a reason his portrait is up at the law school. There's a reason that many liberals in legal disposition, that is, talk about the Warren Court with great fondness. A good deal of their decisions have been chipped away at, but he gave us, among other things, Brown versus Board of Education, one of the greatest decisions ever decided by the Supreme Court. And so, it's interesting. There's a lot going on in this country where we're talking about the role of history, and history is complicated. He is an example of history is complicated, but what I think, and without getting into the larger debate, what I would say is I want his portrait to stay up at the law school because I want to talk about what he did in Brown versus Board of Education, but I also want to talk about what he did here because I think we need to talk about all of it, and we need to learn from all of it, and we need to understand how our country has evolved in the way that we approach these issues. And indeed, the incarceration of Japanese Americans was not just a suspension clause violation. There were huge racial discriminatory aspects to it that would no longer pass constitutional muster, happily so. That's why we teach Korematsu as the anti-canon, that is to say, erroneous decision that it is. So we can learn from all of this, and I think that's the really important message to send to our students.
Two questions. I'm still not quite clear on what the Constitution says about who gets to decide that habeas corpus is suspended.
Okay.
And also, when it is it suspended for all crimes? Or if it isn't, who decides then what's rebellion and treason?
Yeah, these are really good questions. So the first one, it's my position that Congress, and only Congress, can suspend, except possibly, arguably, if Congress can't assemble and take up the matter, which in this day and age of modern technology, it would take something pretty extraordinary for that to be the case. The Constitution puts the suspension clause in Article 1, which is the legislative article. And that, along with all the historical backdrop, I think, together, and the context of people writing a constitution against the backdrop of having deep suspicion of centralized executive authority. So much so that until the Constitution in 1787, there was no executive branch in the federal government under the original Articles of Confederation. I think when you put all that together and the placement of it in Article 1, it has to be a legislative power. Any other argument is completely at odds with the context, the history, and that textual placement of the provision. But even if you accept that, then as your question highlights, there are a lot of really hard questions that follow. So what if Congress declared a suspension? My favorite hypothetical, crazy hypothetical, is to address the invasion of the Beatles. Okay, I'm trying here. So the invasion of the Beatles, obviously that's unconstitutional. Well, can the court say that? Is suspension a political question, in other words? This is actually an interesting debate, and it's the question I answered in the first article I wrote in a line of articles leading up to the book, because I think it's a really interesting question. There are quotes from a lot of prominent justices over history, including most recently Justice Scalia and Clarence Thomas, who's still on the Supreme Court, saying that if there's a suspension, courts are closed, they can't review it, they can't second guess it, that's it. To my mind, that cannot be right. Because if that's right, then pretty much everything is a political question and the courts can't answer it. To my mind, if there's one thing courts do more than anything else and are supposed to do in our constitutional tradition, it is to protect individual liberty. And to say that Congress can just shut them out of the conversation completely, that can't be right. And that does not reconcile actually with the ratification debates, where there was an assumption animating the debates that if Congress abused the power, courts would check the excess at the margins. That being said, can Congress provide for a blunt or an especially broad suspension? Who's going to police the margins of application? How broadly can it go? These are hard questions of application. And I can work through some of them, but what I would say as a general proposition is that the court has to be looming at the margins, checking to make sure that the power is not abused. And the reason I come to it from that perspective and that at least general proposition is because suspension is such a dramatic state of affairs. We are talking about locking up people without any judicial process at all and throwing away the key until the suspension lapses. That's a very big deal, and it's always been a very big deal. And the courts have to check to make sure that we're not suspending to deal with a rebellion in South Carolina, as was done during Reconstruction to address the Ku Klux Klan. I didn't have time to talk about that, but there was a suspension during Reconstruction to promote civil rights, actually, and to combat the Klan. Well, could you use that as justification for arresting and holding people without judicial process in Alaska at the same time? I don't think Alaska was a state yet, but you hopefully are running with the hypothetical with me. That's hard to see how those are connected. And we could take a hands-off approach, but I don't think we should, given what's at stake. I think there's a role for the courts to say, look, there may be a rebellion there, but it's not even a close argument that it's over here. And as such, you can't use the suspension as cover to arrest over here. Now, there will obviously be hard cases in the margins. What about North Carolina, if the rebellion's active in South Carolina? There might be an argument that the court should be a little bit more deferential, maybe, maybe not. But the bigger issue, I would suggest, is that the courts do have a role to play as part of this conversation, even though the point of suspension is to take the courts out of it. They are ultimately supposed to police the boundaries of the Constitution, particularly insofar as those boundaries apply to the political branches.
Yeah, the Japanese internment, a simple question. Are non-citizens in a different situation than citizens when you're giving these general laws about habeas corpus? Do non-citizens have the rights as well, or are they in a different class?
Yeah, so the question is, how does the citizenship distinction matter? And what do we do with that? How does it play out in this body of law? And the answer is it's complicated. One of the reasons I highlighted, in particular, your question asked about the Japanese-American internment, one of the reasons I highlighted that we need to look behind the numbers and see that the numbers would have been dramatically higher in terms of the percentage, which was already high, of who were citizens, because we had racially restrictive naturalization laws that today would be declared unconstitutional without any doubt, but were not actually changed until the 1950s. And so it was impossible for Japanese immigrants who came here to naturalize under then existing laws to become citizens. Now, more generally, the question is, well, how does that line work and what is its significance? And it works in a number of different ways. As a general proposition, it is not a requirement that you be a citizen, or traditionally in England, that you be a subject to claim the protection of domestic law. So the idea, more generally, the legal concept is one of allegiance, which interestingly was the name of the musical that George Takei wrote about the internment. Allegiance is this legal concept that says if you come within, traditionally, if you came within the king's protection, then you enjoyed that protection, but you owed him allegiance. And this concept carried over into American law, and it means that aliens can come and settle here and join our community and not yet be full-fledged citizens and enjoy the full protection of our law. But it follows from that they owe allegiance. And it also follows from that an alien could commit treason, could violate that allegiance. And indeed, there are treason trials of Frenchmen in the 1600s in England. Frenchmen who came on friendly terms to England and violated their duty of allegiance, or obedience, as it is sometimes called. Obedience is said to be tethered to treason. Now, in times of war, it gets a little complicated. Because historically, both in England and in American tradition, going all the way back to the founding, if you are in a declared state of war with another country, then alien enemies, that is to say people living in the country who are from the country with which you are at war, under an American law going all the way back to the founding, can be detained. It's one of the reasons why I highlight in particular that for the Japanese American community, a much higher proportion of individuals in that community would have been citizens, but were treated as enemy aliens when they probably would have been citizens. Today, we obviously don't have the standard declaration of war against nation states, which complicates all of these issues even further. But traditionally, that was the idea. Citizenship was not required to come within protection and claim the protection of domestic law. Instead, it was this floating concept of allegiance that could and indeed did embrace some aliens. But by the same token, if we're in a declared state of war, traditionally, enemy aliens could be detained or expelled.
Hi, this has been wonderful. A question about Lincoln's administration. He was inaugurated and immediately suspended habeas corpus, but only sometime later, much later, Congress followed suit.
Right.
In that period of time, did law enforcement agencies in federally controlled territory behave as if habeas corpus had in fact been suspended? And were there any subsequent consequences to their possible enforcement?
So this is a great question. He asked, almost immediately Lincoln proclaims various suspensions, and the initial ones are very geographically limited. They're very limited in scope. He's protecting certain critical areas as the war is unfolding. Congress takes 2 years to enact suspension legislation. It comes in March of 1863. In the meantime, what is Lincoln doing, and what are people doing on the ground? Lincoln is getting a taste for suspension is the answer. So he goes from these, one guy in Florida type suspensions, one area near Baltimore, and then eventually, in very short order, he declares on his own a nationwide suspension. So that's in operation for some time before Congress then passes suspension legislation in which it says the president can suspend. And they purposefully don't take a specific position on whether what he's been doing has been constitutional, insofar as they want to stay out of the debate. Lincoln then immediately issues a new proclamation, which again suspends nationwide, citing the legislation just to cover his bases. So what's happening on the ground in that interim period before Congress comes in is, yes, everybody is assuming once the nationwide suspension is declared by Lincoln that that's what we have, and law enforcement is behaving accordingly. And you have a lot of political and state prisoners being held, and obviously Confederate soldiers are being held, and they're being called prisoners of war. But interestingly, the suspensions themselves encompass prisoners of war. So that's how they directly purport by their terms to encompass the Confederate soldiers. Then the question is, well, what happens? Like, are courts getting involved? Are there more Tawnies out there? And indeed, this is part of the reason why Congress finally did pass legislation. It was perfectly happy, at least many members were, to let Lincoln just run the show. But because Merryman was on the books, because the Chief Justice had said that Lincoln had behaved unconstitutionally, people who were being swept up in this, including John Merryman, started bringing civil suits against the military officers who had arrested them, suits for the classic tort of false imprisonment, seeking monetary damages. And there was a very real and increasingly growing concern in the Lincoln administration, and Lincoln himself was very worried about this. There were cabinet meetings just on this subject. They were very concerned about being found liable for money damages to some of these prisoners. And so, in fact, the 1863 Act was in response to Lincoln sending his cabinet members and his attorney general to Congress saying, please, please, please pass legislation so that we have legal cover in these cases. And the legislation includes a retroactive provision that says everything that happened before this should be treated by courts as though we, Congress, authorized it. So that was the animating force that led Congress finally to come to the table and engage on these issues. It was a great question. Thank you.
Here we are. We've just seen proof that Professor Tyler is as good at discussion as she is at lecturing. And we'll thank her again.